Can you hear me?
Yeah, I mean, I'll start on that. We can start. And then it'll be good. It's going to be both our observations. Yeah. It's going to be both of our thoughts. So this is what. And then that'll just be.
Started right away.
Okay, we've got the PowerPoint presentation figured out.
All right. So first, we want to kind of address the scope of the issue. Right now, 44 million Americans owe more than 1.6 trillion in student loan debt, and the average debt is held by students is about 33,000. And of course, this amount of debt weighs heavily on students. It has very serious repercussions. Many feel it delays homeownership, it delays many of life's decisions that you make at this point in your life upon graduation. So it's become a great weight on both the student and the economy. Now, currently, student loan debt is extremely difficult to discharge in bankruptcy proceedings, and we just wanted to point out a couple of factors. One, Social Security can be garnished to pay government student loan debt. 25% of student loans are currently in default. As anyone watching the election has seen, student loan has also become a centerpiece of the 2020 election. And right now, some wonder whether Congress and the courts should re-examine dischargeability of student loans.
Right. So, I mean, I just heard on the news the other day, one argument is maybe we can just forgive all government-owned student loan debt. Government owns more than 90% of all student loan debt. And of course, another discussion is, well, maybe you change the bankruptcy code or certain laws. Well, I guess just amend the bankruptcy code to deal with that. So what has happened in the past? Before 1976, this wasn't an issue. Student loan debt was dischargeable the way any other kind of debt was. But, who knows the real reasons? Almost certainly because of an explosion of people who are now going to college and obtaining debt. There was this panic in Congress and in the public, fearing that it's just not fair. And when you think about it, that is a reasonable argument. It's just not fair. You go to law school, you get your $100,000 in student loan debt, you file bankruptcy the day you graduate, and you say, I don't have a job yet. I'm getting a job tomorrow, but I don't have a job right now, and I'd like my $100,000 in debt discharged. Now, it turns out people weren't doing this. Whether or not this matters or not, there was a study right after 1976, or I think the Congress commissioned a study, and it showed that at that time only less than 1% of all student loan debts held by Americans had been discharged. So,
but unfortunately, that didn't really stop Congress from sort of taking on this issue and getting people riled up to do something about it.
So you've got kind of a hysterical mass panic argument that if we don't make student loan debt impossible to discharge, everyone's going to be running to bankruptcy courts to do that. And as anyone who's gone to bankruptcy through the bankruptcy process knows, it's not pleasant. And that reason for making student loan debt difficult to discharge may not really be the real reason. Maybe there's others. So what we've got is a series of congressional acts. And so we go through a timeline in which the first solution Congress came up with was to make debt dischargeable if it was 5 years old, and anything prior to 5 years old could be discharged only if there was a showing that payment from future income or other wealth will impose an undue hardship on the debtor and his or her dependents. There is no definition for undue hardship at the time. That essentially remains true today.
And I think that's what started everything. I think that the lack of the definition really caused confusion, and court decisions were coming out all over the place before Brunner, the case in Brunner. But I think the real crux of the issue is there was no definition in the code regarding undue hardship.
And I have thoughts on that now. I mean, one of the things that is confirmed in my mind talking about the Brunner Test and thinking about it is that we really do need to go back to that one sentence in the bankruptcy code, and we're not there yet. We're not there yet as to what that one sentence says, but maybe it says more than some people think it does. Maybe it says more, and maybe that can guide what the appropriate steps are at this point. So back in '85, when you've got this regime in which debt could be discharged, student loan debt discharged without a problem, or at least regularly discharged after it was 5 years old, then you've finally got the now dominant, the now totally overwhelming and prevalent decision on the subject that comes out of the Southern District of New York, adopted by essentially everyone, and it's the Brunner Test. And so, because it's just been adopted, we just call it Brunner. But there it is. It's this 1985 decision. And so what the district court in the Southern District of New York said is, okay, if we're going to determine what an undue hardship is for the debtor and his or her dependents, three-part test. And it's can you currently, based on your current income and expenses, maintain a minimal standard of living for yourself and your dependents if you're forced to repay the loans. Second, is the state of affairs likely to persist, looks to the future, for a significant portion of the repayment period? And third, has the debtor made a good faith effort to repay the loans?
So really the way to look at this test is look at the present, look at the future, and then look at the past. So it's kind of it attempts to be sort of a holistic approach to look at the debtor's circumstances and try to gauge the future, try to gauge what can the debtor do, or has the debtor shown that it really is going to be an undue hardship, looking at what they're incurring, what's happening in the future, what has happened in the past, and based on that, what's set to happen in the future. The next thing is the Brunner. When Brunner was decided, as Steve mentioned, there was a time limitation, and the test still remains the same. And most of the circuits have adopted the Brunner test, including the Ninth Circuit, except for two circuits, the First and the Eighth Circuit, that use the totality of circumstances.
And if you care about the timeline of this, which is mentioned, it is mentioned in cases, and it's mentioned by courts who criticize the Brunner test. They say this timeline, the timeline that you're looking at now, not only the 1985 decision of Brunner, but 90 and 1998, means that we shouldn't be applying the test like this, because in 1990, the Congress extends the time period that must expire to 7 years for debts to be dischargeable as normal. And then in 1998, it eliminates the expiration date entirely. So as starting in 1998, if you've got a government student loan, government-backed student loan of any duration, you've got to pass the undue hardship test. That happens to be the same time that the Ninth Circuit adopted the Brunner test.
And really what that means is that now you have all this body of case law with this extremely harsh undue hardship standard that was adopted during a time period when they could be discharged after a certain period of time, now being applied in a time when there's no time limitation. So you have to show undue hardship, and the test at this point becomes so harsh that over time it's become sort of the certainty of hopelessness standard that it has evolved into now. And then in 2006, just a quick note, it then extends to private student loans.
So I used to think that the statute today, which is in the Bankruptcy Code, and it's 523A8, it's just this section and there's no other. I used to think that this was just a two-word section, and that's why we have so much of a challenge with undue hardship. But I now wonder, and I wonder based on decisions that are showing up even in the last couple months, that even bankruptcy courts are now looking at this sentence. What is this sentence? It's here, but here's the phrase: is discharged doesn't discharge an individual from debt, and then here's a phrase: unless accepting such debt from discharge under this paragraph would impose an undue hardship on the debtor and the debtor's dependents. And then there's an explanation of what student loan debt is. But that's a phrase. And it begins right after number 8. it begins with the words unless accepting such debt from discharge. And that's a relevant phrase, as courts are now pointing out, and we'll get to that in a little bit. But this phrase not only mentions undue hardship, right, but it mentions the debtor's dependents. It's right there, debtor and debtor's dependents. So it's, all right, so now that expands the scope of what we look at. We know what Congress means by that. And then there's that precatory language, which is unless accepting such debt from discharge. Now, what does that mean? Now, it may mean that you have to take this into consideration, assuming that you make the payments that you're required to make under your loan, and that by modifying that even a little bit, you're not following the language as is expressly written in 523A8. We'll get to a case that talks about that.
And just to back up a little bit, I'm going to slow you down, Steve. There are, you still have to qualify as to be under this exception. We're not going to be covering that in today's presentation and going into detail, but there are some creative arguments that are being put forth by attorneys across the country, examining whether those loans even qualify under the statute. And so I just wanted to point that out.
Occasionally, people do make the observation that the term undue hardship does show up in another section of the Bankruptcy Code. It's 524, relates to reaffirmation agreements. That argument will not be successful. It's been made and rejected in a number of cases. The argument is along the lines of, in section 524, undue hardship is defined as monthly income minus monthly expenses, less than scheduled payments. Therefore, use that in 523A8.
Right.
Nah, it's not going to work.
All right, so I mentioned this earlier. In order for a lender to qualify under this exception and get protection, they first have to be defined as a qualified educational loan. Now, as I mentioned, there are interesting arguments being put forth across the country, so it is an issue that it's important for you to flag when you have a client. First examine whether these loans even fall within the exception, because lenders do have the burden of proof to demonstrate this.
So maybe the banner at the top is Brunner still good law is not the right banner to have, but it's something that I wanted to mention that's worth thinking about, because if you go back a couple slides to that sentence in 523A8, any bankruptcy court, any judge is going to look at that sentence and say, okay, I've got to make a determination. Unless accepting such debt from discharge would impose an undue hardship on the debtor and the debtor's dependents. And so how am I going to do that? Well, there's lots of answers, but here's answers that may not be good answers. Maybe one of those answers is to say, there's a good faith requirement. You've got to show good faith. Well, maybe that's true in bankruptcy cases generally. I mean, it's certainly going to be true in anything a debtor files. 523A8 doesn't say that it would impose an undue hardship on the debtor and the debtor's dependents, provided that the debtor and the debtor's dependents are operating in good faith. That section doesn't say unless accepting such debt would be an undue hardship, provided the debtor has made past payments of a reasonable amount. It also doesn't say, regardless of the future, if the debtor this day at court stated that they happen to have $5,000 in their bank account and technically can make their next 2 months worth of student loan payments. So there's all these things that can be read into undue hardship. They actually were read into undue hardship in the Brunner Test.
Right. And I think that's one of the issues with the test is that in a sense the test took a life of its own in basically becoming undue hardship, when that's really not the language of the statute. The language of the statute is pretty clear, and it's not certainty of hopelessness. It's not, will you never be able to repay these loans. It's basically, do these loans cause an undue hardship? And I think one of the reasons, probably historically, because the test was adopted during a time where, there were some time limitations in place, the court felt at that time that it was appropriate to make it a high standard, and those circumstances have changed. So it really is. One can see it more as an old test that really is, in many ways, outdated and unduly harsh because there is no time limitation. So now we're seeing clients have these debts linger for 10, 20, 30 years, and that has huge ramifications, not only on their present circumstances and their ability to own a home, start a family, but also on their retirement. As we mentioned at the first slide, Social Security income can now be garnished. And really, these are loans that are basically following you for many of our clients until they die.
So as tempting as it is for any bankruptcy attorney to go into court and make the argument, that we're talking about, it's, we realize that in the Ninth Circuit, certainly, a bankruptcy judge is going to say that I'm bound by Ninth Circuit precedent, and that precedent is the 1998 decision adopting the Brunner Test. And so certainly the Ninth Circuit could change its mind. The Supreme Court's never weighed in on the subject. But we're with the Brunner Test. It's just worth remembering that some aspects of it can't even necessarily easily be read into 523A8. But here we are. We're stuck with it. The debtors have the burden of proof. It's going to take a trial. It requires a separate adversary proceeding, which almost certainly is a great disincentive for the average down on their luck debtor to want to do, almost certainly because one of their engagement agreements with their bankruptcy counsel said that bankruptcy counsel is not going to be representing them in connection with long drawn out adversary proceedings, including to attempt to discharge student loans. So it takes a trial, it takes a complaint, it takes discovery. The debtor will be deposed. The debtor is going to be deposed about all of their expenses, all of the inheritance they received, every time they received a tax return in the last 10 years, every time they've made a student loan payment, the amounts of all of those student loan payments, how many resumes they've sent out in the last 10 years, whether they're likely to get a better job, all very unpleasant, questions. And that's what occurs. Can you write an article in 2007 about how, maybe you actually do have a reasonably good chance at obtaining a discharge? It's just there's a perception that it's so hard that people are not doing it even when they could. Yes, those articles are there. But
also, one of the things I want to stress is it's costly. I mean, for many of the debtors that want to show undue hardship before the bankruptcy court, it's an undue hardship to show undue hardship. That means hiring an attorney potentially. That means trying to find funds in some way to hire an expert to demonstrate either some sort of substantiate or corroborate some sort of physical or mental disability. It takes, possibly taking time off work to attend a deposition. It takes time off, just to gather all the documentation. A lot of the times it's difficult to get past bank records. And a lot of that also takes additional funds that the debtor does not have. So that's a point that I just want to put out there, that oftentimes we have worthy candidates, but it's a very expensive process. Even when it's pro bono counsel, if you have an attorney representing them, is it really fair to put those costs on a pro bono attorney that's doing it already for free to then have to subsidize having to pay for experts? And it's a quandary because on the one hand, judges are evaluating somebody's mental or physical health as well as prospects of job prospects in the future, and they want some sort of way to substantiate it other than the debtor's own testimony. But oftentimes the debtor can't afford to get those experts, so it's a tough spot to be in. So that's another obstacle that many debtors with worthy cases have in bringing these cases.
I did read an interesting study that was done a while ago, though, and it said that there was no statistically significant difference in success rate between debtors who were going pro se in these adversary proceedings and debtors who are represented by counsel, which I thought was interesting. But also, certainly, you could imagine that a pro se debtor going to trial asserting that they are down on their luck is going to be pretty believable to a judge versus necessarily a debtor who's been able to hire an attorney to make those arguments. I just note that for anyone who is asked by one of their clients, do I have a chance of doing this without an attorney? The answer is, yeah, there's a judge will listen to you.
They may listen to you, but at the same time, if the case is appealed, sometimes the grounds for the appeal is that there's not enough evidence to substantiate those injuries. So I do think that even representing yourself a pro se has its dangers, because if you don't show enough proof to withstand an appeal, then you're back where you started. Okay, so we're going to go into the Brunner test, the first factor. This is really the present, and usually it's not the most difficult prong in the Brunner test, because basically what you're trying to show is, based on the debtor's present circumstances, they can't maintain a minimal standard of living. Of course, if you're looking at your bankruptcy petition, Schedule I and J, you basically look at your expenses, your income, and your expenses, and see whether the debtor can pass that test. And usually it's not too difficult. And I would say that if you don't pass this test, I wouldn't really probably go much further, because if there is some ability to pay presently, I think most judges may be reluctant to explore the other two factors and basically deny based on that, not even going to the analysis of the second and third factor.
Yeah, certainly. I mean, it's the initial conversation you have with a client is what are your current bills and what's your current income, and what can you do. It's also not one of the things that you would think 523A8 would require, because 523A8 speaks to undue hardship in the context of future burden to yourself if you have to repay your debt. Well, here we are now at a factor that doesn't address that at all. But maybe the best way of thinking about it is that, fine, we're looking to the future, and the only way we can really do that is by trying to figure out where we are at stage 0, which is today. And so there's two elements. There's income and expenses. Income's not going to be that difficult to show. In fact, it should be fairly straightforward. What do the cases say that that talk about this in an interesting way? You'll see throughout the rest of this presentation, we've identified cases in italics. They are all in a glossary at the end. They are all cited at the end, but we just, in order to keep this presentation readable, we put those sites there. So, it's possible to show up and say my income is X, and for a judge to say no, it isn't. It isn't, because you artificially decreased your income. And so I'm not accepting that you can meet the first factor of the Brunner test because your income is only X. It really is X plus 20%, because it has been in the past. You're currently doing some other activity that's preventing you from maximizing that. So that happens.
Yeah, I think that if you do have a debtor who has an advanced degree, I think it would be helpful to show, well, why, is there some barrier as far as why that he can't be successful in pursuing a career in that degree, or has he attempted to pursue a career? For example, if you have a law degree, has he attempted to be practicing as an attorney, but it has been unsuccessful, has sent out all these resumes, but no one's hiring him, has attempted to start his own practice, but wasn't able to do it. I think that if that's the case, I think it is important to show those efforts. I think it's less of a case if you have a debtor who really has topped off their income, they don't have an educational background that enables them to get a high-paying job to service their loans. At the same time, if they want to advance, that requires them to take on more educational training and more loans for a future that still may be pretty speculative. So I think that's important to highlight in as well from your debtor situation.
The cases seem to reject most, hypothetical arguments against this income, an income statement by a debtor. For instance, someone could always go into court as a defendant and say, well, the debtor could move to, a bigger city. Courts don't really follow that. There's got to be something that's apparent. What is apparent that isn't necessarily obvious is, if you're married, spouse's income taken into account. What if you're dating? That income might be taken into account if there's some evidence that your significant other has been paying for your expenses in the past. What if you've got a child who's 17 and about to turn 18? It might be that the court might say, well, they can be contributing to in a hypothetical way, and so we're going to impute income to you. Nevertheless, this is going to be the first speed bump that should be fairly easy to pass. So now on to expenses, and as you can imagine, this is just a big mess because you've got to write all your expenses on Schedule J, and every single one is going to be looked at, and every single one is going to be criticized. Now it's not as easy as looking to federal poverty guidelines and and saying, but courts sometimes do that. But it really is, you're going to have to justify your $200 cell phone bill. And maybe you got a problem if your student loan monthly payment would only be $250, because it would be very easy for a court to say your $200 cell phone bill can simply be deleted from your expenses, used to pay your student loan, and then you're fine. So any debtor is going to have to expect rigorous look at this.
Yeah, and it really depends. I mean, when I review some of the decisions, it really depends on the judge and how much they're going to scrutinize the defendant's or your client's, the debtor's expenses. And so there's a lot of variation. I mean, I think some judges take a much more reasonable approach and saying, hey, you need cable. Now in today's society, everybody, communicates by cell phone. You do need a computer. You do need certain things. Whereas other decisions take a much more draconian approach to this test. So they really want somebody to basically be living, hand to mouth, and it's just, almost, how are they expected to even try to maximize their income given the limited expenses that you're allowing them to have. So this is one of those areas that really kind of varies, but I think the more that you can show that your debtor is making their best efforts, is in a pretty reasonably tight budget. It's not, definitely don't show, eating out 3 times a week at, high-end restaurants. But it's not as, also charity has sometimes been questioned, charity payments. But I think so long as the expenses are reasonable, usually this is not going to be an issue.
So this is the point in trial in which the defendant makes the following argument, that in the past, 10 years, income-based repayment programs have become, widespread, accessible, somewhat accessible, known, somewhat known. And so therefore, if the debtor were to have signed up for one of these, or maybe the debtor is currently on one, the debtor would have to pay some percentage of their income above a certain level. And judge, I'm signing something right here showing that if the debtor were to make this payment this month, the payment would actually be $0 or some amount that's very low. So therefore, judge, you cannot find that it would be an undue hardship for the debtor to pay this debt, because I, the defendant, am admitting that they could pay $0, and that would permit them within 10 years, 25 years, 20 years to get a discharge of that debt. That argument doesn't really work. There are subtleties to it, however, and the subtleties is that we all must be aware that these IBR programs exist, and they will be the language that a lot of these cases talk about. Is it reasonable if an IBR can reduce a payment a little bit? Say your monthly payment's $500 a month, an IBR program reduce it to $300 a month. You have just enough expenses to make that $300 a month. It's going to be a strong argument that you're just going to have to face. It's going to be made against you, and a judge is really going to have to. Well, I think,
again, it's not in the language of the statute. So I think that it's important to remind the judge that IBR programs were available even when the statute was passed, and it's not a requirement that somebody be on an IBR plan to show good faith. I mean, a lot of these IBR plans, there are many issues that have existed. There's with these IBR plans, a lot of times debtors are not told about these IBR plans, so they use up their forbearances. That's one issue. These IBR plans last 20, 25 years. There's recertification requirements that they meet every year. And I can't imagine the stress that causes a debtor, say, in one of these plans on year 15, say they get sick and can't meet that, and all of those 15 years they're done because of that IBR plan. Also, there's just this uncertainty about these plans with regard to, there has been talk in the past about whether the public service loan program should be continue getting funded. I think the same could be said with some of these IBR plans. The future is uncertain with regard to the viability and also the debt consequences the tax consequences that may occur once these plans come to fruition. So I think that, one of the things to point out to the courts are when you're addressing this argument is to make sure and address some of the issues that exist with these IVR plans, and to not allow that to take over the test and say, oh, just because the payment is zero. Well, it's not really zero. The interest is still accruing. The balance is still accruing. Technically, I guess the debtor is current, but they're not really. I mean, that debt is still hanging over them for the next 20 to 25 years.
So if it weren't for IBR, the first factor would be simple, which is what are your reasonable income? What's your income? Is it any reason to impute income to? No. What are your expenses? Okay, so now what is X minus Y? Or what is Schedule I minus Schedule J? And is there a difference? Not much. Okay. Is that difference enough to make your regular monthly loan payment? Probably not, because if it was, probably this person would not have, probably is in better financial shape than a lot of people who are in these dischargeability cases that are reported at least. And so if your student loan payment is $500, but you only show $300 worth of excess income, you pass. So it's almost easy and logical. 300 is less than 500, therefore you pass. There's a challenge to that, which is multiply those numbers by a factor of 1, by a factor of 10. And if you were to go into court and say, Judge, I've got $3,000 extra every month, but I pass because the evidence shows that my student loan payments would be $5,000 a month. We're probably not going to get too many cases like that. There are some. In those kinds of cases, you expect difficulty, because it's going to be very hard for a court to look at $3,000 of extra income a month and say, this is the case that I'm gonna go out on a limb on and say you get your discharge because $3,000 is less than $5,000.
And usually these are not the cases we're going to see. The cases we're going to see are individuals that this factor will not be an issue. Other than addressing the IVR issue, I think for the most part it'll be fairly straightforward. Okay, so the second factor, this is by far the most difficult of the three factors. Why? Because it tries to evaluate the future. It tries to look at the debtor's present circumstances. It tries to look at, in some ways, the past to evaluate what the chances of this individual debtor standing before the judge are to repaying the debt. So this often makes it difficult for young persons to obtain a discharge because, they're at the beginning of their career. Who knows? The possibilities are endless. Even though there isn't a history to demonstrate that their promises have been that promising, I guess, in the past, it's sort of this attitude of, well, you never know. This also makes it difficult for an unemployed person to obtain a student loan discharge because there's always a potential that they could be employed in the future. One of the things that the courts really look at are age. So if you're much older, I'd say 50s or 60s. Now, as I'm getting older, that doesn't seem that old, but the courts do seem to use that as a marker. And then a demonstrated track record of an unprofitable career, or as some courts term it, you've maxed out your employment advancement potential. And so those are seem to be the predominant factors aside from, demonstrating to the court that really, despite the fact that there is this sort of uncertain future, I think it is important to point out to the court how important it is to look at the person's history. So yes, maybe you could win a lottery ticket. Yes, maybe you could inherit, but those are really going above and beyond what the statute requires. Yeah. Really, what the statute requires is, are they likely to persist for and this is important, for a significant portion of the repayment period of the student loan, and that's going to be a point of contention with some of the lenders. Really, the standard, the period should be, with most student loan contracts, the 10-year standard loan repayment period. What some lenders try to argue is, well, with these IVR plans, now you have 20 to 25 years. Well, that's not in the statute. It's convenient for lenders to want that to be the new standard, but it really isn't, and some cases have found that as well.
Two things. thankfully, we have a Ninth Circuit precedent here that talks about the future and the crystal ball issue and trying to predict the future. And it just says you can make reasonable predictions, but anything that's not reasonable, that's not going to hold up. That's not going to hold up meeting this factor. So that solves your, judge, anything could happen, so therefore the second factor can never be met argument that someone might think about making.
And I think it's important, and I'll just chime in a little bit. It is important when you're making that argument. It's basically you're signaling to the judge, well, if that's their argument, then basically there is no discharge. There is no right to a discharge. I think it is important to remind the judge, look, the statute is part of the code. You are the one in charge of determining undue hardship, not the lender. And if the lender wants to create these standards that basically eviscerate any possibility of any debtor under, on the one hand, you're saying, oh, there's a little money there. Yes, you can make it. There's a future potential. But then you're taking the opposite view of say, oh, this debtor is so destitute, they can't make any payment, but still you have IBR. So basically, they're putting debtors in a box where basically nobody is entitled to a discharge, which clearly cannot be the standard for under 523AA.
There's some cases cited at the end of this in which debtors got discharges, and I've identified some of the facts here, and some of those numbers, kind of suggest that there's a pattern here, and maybe so much of a pattern that what's the point of arguing that Congress should amend the bankruptcy code to say student loan debt should be difficult to discharge, for the first 15 years, but afterwards is easier, because it's already that way. I mean, there's no way that it's going to ever be easy for someone younger than the debtors identified on this sheet to get a discharge and convince a judge that there's no way they're going to have a better career.
Yeah, I mean, I think the only exception to that, the only caveat to that is if they're young and they have some sort of disability, or they have some issues where they really can demonstrate to the court, my future is just not going to be any brighter, and there's not going to be that much of a potential for me to make income. So, I wouldn't say age is a hardline rule, but I think if the debtor is younger, I think you do want to go the extra mile of getting additional evidence to show, well, why this particular young debtor with, maybe 30, 40, 50 years still of working life available cannot make something. So
the second thing I wanted to say that I forgot to get around to a couple of minutes ago is that this Rosenberg case that is mentioned here at the very bottom part of this slide, it's cited in the back. The materials that got sent out the other day to everyone on this webinar attach it. It came out 23 days ago, and it had, to me, an interesting comment in it that I'd not seen, but then having looked at it more, I think I found one other case that also talked about it, which is that, okay, it's nice to talk about, it's nice to talk about the future, but 523A8 doesn't say that. 523A8, if you look at it, it says will be an undue hardship for the debtor and their dependents if for the remaining term of the loan, or would impose an undue hardship on the debtor and the debtor's dependents unless it is accepted. And if the loan is due and payable today, that's an undue hardship. It can't be paid today. And the Brunner Test says that too, because the Brunner Test in its factor 2 says, okay, we got to look at, the burden to the debtor and their dependents over the future repayment period of the loan. Well, if you've got a defendant that, the day before the bankruptcy case sent a letter saying, a significant portion of the repayment period is the Brunner Test standard. If you've got a defendant that, the week before the bankruptcy was filed, sent a letter saying your loan is currently due and payable, my reading of the Rosenberg case is, congratulations, you've just passed your second factor of the Brunner Test, because you don't need to look 20 years in the future to argue that you can't pay this loan back. You need to answer the question, can you pay it back today? This is the term of the loan today. Judge, I cannot do that past. That's the Rosenberg decision, and it's been appealed.
Yeah, notice of appeal has been filed. I think the Rosenberg decision did go through a very careful analysis of each of the factors. So I encourage you to read it because I think it revisits some and questions some of the unduly harsh standards, such as the certainty of hopelessness, and addresses how many of those phrases that we now associate with the undue hardship test are basically judicial gloss that's been put over time and time over the years during a time period when there was time limitations on the dischargeability of student loans, which no longer exists now.
Just in case you thought that we were telling you guys it's easy to get a discharge.
Oh, here are some where it shows that the second factor has not been met.
In cases maybe where it should have been.
Right, and I think that that's another issue, and this is sort of an issue just generally, is when you look at cases nationally, it's interesting because of the flexibility or sort of the harsh standards of the undue hardship test. You get these results where you see one debtor where they're like, well, they seem completely worthy and they're denied, and then you see other debtors where you're like, well, maybe a payment or two or some sort of settlement could have been reached, and they're granted a discharge. So I think what the second factor also leaves is a lot of discretion, and I think that we'll talk about it later in closing remarks. But that's where you see this lack of consistency with some of the ways that the factors are weighed against debtors. Some personal biases with regard to certain life decisions potentially, and certain biases that maybe the judges have with regard to whether they believe this test should be harsher or more flexible. And so I think that because of that, you get sort of this array of decisions where some seem unduly harsh and then some seem pretty reasonable, and then some seem like, well, that's kind of on the fence. I'm not sure why this person got a discharge and this person didn't.
Yeah. So my view of the Brunner test is it's a story. It is that you're telling the judge a story, and the Brunner test is the test the judge uses to figure out the holes in your story. And the second factor of the Brunner test is where that's going to be discussed, even if it doesn't fit there. So are you a debtor that just got put in jail because you were an IRS agent and you solicited a cannabis company for a bribe and got turned in? You're not going to get a discharge. That's a reported case a couple of years ago. Is it because you have a likelihood of being gainfully employed as a convicted felon? Probably not, but it's going to be talked about in the second factor.
I've even seen factors such as, you basically have so many children. Why'd you make that life decision? And so I think that this, it depends on the judge. It depends on, the judge's view of what life decisions he deems, or she deems appropriate. But I think that it is something to make the client aware of that, some of these are factors that, are taken into consideration even when they shouldn't be, because they're not under the clear reading of the statute.
Yeah, so I guess practice pointer would be, have your client send out some resumes, be able to get something in front of the court, say I'm looking for better employment and I'm having a hard time. It's going to be, when a debtor loses, they lose on this factor. Sometimes a court says the debtor loses on the first factor, so we're not even getting to the second, but really the court's still talking about the second factor. It could be reasons that just aren't going to show up in reported cases or even in the Brunner test. There's been no reported decision yet that discharges more than $300,000 in student loan debt. There's been no reported decision that discharges a small amount of student loan debt. Maybe there's one at around $8,000 or $9,000, but if you show up with $5,000 in student loan debt, it's going to be very easy for a court to come up with some reason why that shouldn't be dischargeable. It's not in the law. It's not in any reported cases. It's just this is where you're going to lose on the second factor, and you may not even know why, but it could be these unknown reasons.
Right. And, as we're talking about the different decisions that courts make, this is a difficult test. Having a judge trying to predict the debtor's future prospects, that's difficult. I mean, it's a challenging, you're trying to tell a story. So I think it's important to remind the judge when you're putting your debtor forward and presenting his case to really look, I mean, to look at what the debtor has been able to do in the past, because, and reminding the judge that these are the process based on that debtor's life experience so far. And that to create these sort of mythical standards that, oh yes, I know this person has only, been able to, barely scrape by for the last 10 years, but who knows? Maybe in the next 10 years will be much more promising. Well, for many clients, especially if they're close to retirement age, the future is not going to be more promising. There's going to be added expenses. There's going to be added health expenses. For many of our debtors, the most expensive time of their lives are going to be in the later years, with added health expenses, with possibly lowered income, because if they retire, possibly many are just living on their Social Security income. It's important to remind the court that the Social Security income can be garnished. So these are factors that are important to point out to the court, because it is challenging for the court to make this determination, especially when you're looking at a lot of factors that you have to
consider. This is where, in my mind, the practical reality of a debtor's life meets with what I would want in my ivory tower to tell someone who's saying, so what are my chances of getting this discharge? In my ivory tower, I would say the following. I would say that if you look at these cases, and in the next few pages we cite them, there are fact patterns that show pretty clearly what you need to do to meet the third factor. Setting aside the argument that 523A8 doesn't have a good faith component, setting aside the argument that it really doesn't even have anything to do with the language of 523A8 as to whether future payments are going to be an undue hardship. The past shouldn't even matter if you look at the sentence of 523A8. Setting all that aside, what does the third factor look at as written in the Brunner? Look at good faith in making past payments. All right, what does that mean? It means you're going to need to make a dozen or more, probably more if you've been out for decades, and they should be in significant amounts. And then the reality hits, and the reality is, how can I do this? I'm trying to survive. It's not so easy.
Yeah, I mean, I think that the caveat to that would be if the debtor can't make those payments or has not been able to make the payments, I think it's important to demonstrate efforts that they've made to work with the lender, either getting on an IVR plan of some sort or trying to make efforts to work with the lender, because oftentimes there is no payment that can be made by the debtor. And so the fact that they haven't made one should not be fatal, but I think it is important to show to the court, look, they reached out to the lender. Even if they do get on an IVR, the payment would be zero. So it's really inconsequential whether they sign up for one or not, but at least the debtor is making those efforts.
So, I mean, it's nice to tell a client or tell someone inquiring, so what do I need for this? Well, if you can make 20 years of payments, you're on easy street for the third factor. And then, well, the reality is they, I haven't made 20 years of payments. Does that mean I lose? No. I mean, there's cases which say you don't need to pay at all. But it's an issue. Why is it an issue? I'm going to go to this next slide maybe before anyone gets to see what's on this slide, although the cases are in the back. It's an issue because if you don't pay ever, that is so easy. That is so easy for a court to say, you know what, not today. And I won't even say that that's the reason that I'm denying your discharge. I'm going to say it's because you haven't met the second factor, which is, I can talk about more. But if you've made only one payment or none, you lose. That's not what 523A8 says. It's not even necessarily what the Brunner Test says, but it's how courts have interpreted it.
Right, and I think because of that, it's important to remind the court of the efforts that your debtor has made, and if there haven't been efforts, why it's prevented them from making any payment at all. It could be that they haven't been working all that time. It could be a variety of factors that have prevented them from making any payment at all. So I think it's important to at least bring that to the court's attention, especially if the payment has been zero.
I mean, it's not so easy to say payments of $5 a month mean that you lose, because that's not true. There was a case that came out 2 years ago in which the debtor did make payments of $5 a month, and the court cited that as evidence of good faith. It's just there were other factors that related to good faith as well.
So summing up the third factor, I guess we're just saying, have the debtor, or present to the court that the debtor has tried their best, whatever that best may be, whether it be reaching out to the lender, try to show that there has been some efforts by the debtor to reach out to the lender, try to negotiate a repayment plan of some sort when they were able to, even if that means requesting a forbearance, whatever that may be. Just show some efforts by the debtor of what they have done, and if they haven't done any efforts to do that with the lender, then show why. Because the judge, even if the most reasonable judge, they still have to, they're still bound by this Brunner test, and they want to at least have a decision that has examined this issue and has some evidence as to justify why they're granting a discharge.
So, First and Eighth Circuits don't use Brunner Test. I'm not sure there's any studies out there that say anything other than the tests have equal results. If the Ninth Circuit or any of these circuits were to say, you're right, we shouldn't be using the Brunner Test. What's the alternative? The alternative is going to be, I got to look at every single fact of the case, and those facts are going to include, as you see here in this list, many of them are already in the Brunner Test. They just look at other factors too. And
I think it's important. True that the First and Eighth Circuits do look at totality of circumstances, but that doesn't necessarily mean the trust is going to be that less harsh. The judges could look at all these factors, many of which are in the Brunner Test, and be equally, it could be an equally difficult standard depending on how much weight that particular judge is giving those factors. So it's not necessarily always the case that just changing the Brunner Test to the totality of circumstances will mean less of a burden to your client. I do think it does give the judge much more flexibility because they're not bound by this very strict language in the Brunner Test, and also this body of law that has become so harsh as far as the standard being, certainty of hopelessness, and which has always been interesting to me, because on the one hand you're saying your standard is certainty of hopelessness, but yet you're giving debtors a fresh start. So it's always been sort of an interesting juxtaposition of putting those two concepts together. But because that's been the language that has evolved within the Brunner Test, I do think the totality of circumstances does give judges a little bit more flexibility if they're so inclined.
The arguments made by defendants in these cases about how the debtor should enroll in an IBR program do not appear in the second factor. We've already talked about how they appear in the first factor, and they appear again now in the third. And this is maybe where the court talks about IBR the most, because this is, I suppose, if you're looking at good faith at all, this is kind of where it goes, even if you're not looking at ability to make past payments or actually making past payments. You talk about IBR here. There's, as we've said, there's decisions that will come out and say there is no per se rule. There is no per se rule, and we will not we will not rule that way, that if you don't enroll in if the fact that IBR exists means you cannot pass the first and third factors. We reject that completely. You've got cases like this Murphy decision here that say, okay, well, not only that, but there may be lots of good reasons for people to not do this. So a debtor's relationship with the IBR program is itself going to be on trial. They're going to be asked about it, and they're going to be asked about their thoughts about it. And the worst answer is, I don't know, never looked into it, don't care. That makes it easier for a court to say, well, all right, I'll take that into consideration. So come up with something to discuss on this third factor about how IBR may work for your client, may not work for your client. Keeping these factors in mind.
Yeah, I mean, I think what's important to stress about IVR, it's not this panacea that it's purported to be. There are many issues with it. There's this long 20 to 25-year period that basically the debtor is on probation, basically having to recertify that they cannot make these payments. That's a long time. I mean, if you think about the average, if they're going to law school or medical school, and they graduate, late 20s, early 30s, we're talking about they're about in their 50s, mid 50s by the time they meet this test. That means during that period when they're, most people are, buying a home, having children, saving for retirement, they're likely going to be foreclosed from those possibilities because they're on these very stringent IVR programs. Now, some can take the opposite position, saying, well, these are your loans. This is an obligation you voluntarily took on, which is true. But if they have met the undue hardships test and they really can demonstrate to the court that they cannot pay these loans back, and they, evidence is presented before them that is compelling, then IVR shouldn't be an obstacle because it's not within the statute. And that's something that you have to really lay out for the court. You have to lay out some of the problems with the IVR programs in its administration, its recertification. Over 50% of people that are on these plans default. There's mounting indebtedness, so you're not getting rid of the debt per se, even at the completion. And also, I think one of the factors that may be overlooked is just the emotional toll that this takes on an individual of having this mounting debt, because during that whole period, it's not just for being on forbearance, it's actually growing during that period of time. And that's not going away until you are at the end of 20 to 5 years, which at that point would, for most people, be around their mid-50s, close to Social Security age.
So this is our last slide of substance, and the remaining slides in the PowerPoint are cases, both granting and denying discharge, and some other citations. And so, this is my opportunity in a minute, and Maggie in a minute, to give my final thoughts. And here's my final thoughts. To the extent that someone comes up to you and says, I think I want to try to expand the boundaries of the law and to see what I can see, the barriers I can push out and see what I can do, is I think the first consideration is you really would like a debtor where there is just going to be no dispute that they are living a Spartan lifestyle. They are. The reported cases certainly show that. The reported cases, it makes it easy for a judge if the debtor can show they can't pay their utility bill some years. They may not have been able to pay their taxes sometimes. They're late on other basic things. Healthcare. I mean, they're living in a one-bedroom apartment, not a two-bedroom, because apparently that's some issue in some courts, and you don't pass on the first test. And so you got the Spartan lifestyle. Second thing that you would want is that there's a good faith story they can tell about themselves as to how they tried to pay. And did paid some, maybe 1 year they didn't for this reason, that. And that is, in my mind, a baseline. From that baseline, courts can do perhaps interesting things that change how Brunner is applied. And I sense that the Rosenberg decision that came out 23 days ago is along those lines, because you have those two factors. Debtor's living a Spartan lifestyle. Good faith, debtor was ex-Navy. Had made, 13 years of payments, and he'd missed some during that time, but he made 13 years of payments. Factor two, passed without discussion. Why? Essentially without discussion. Why? Because you'd been able to satisfy the Spartan lifestyle, the good faith, and then that made it very easy for the court to say, I see that your loan is due and payable now. I find that the second factor is met because you cannot pay it today, and therefore you cannot meet the literal language of the Brunner Test and I'm going to ignore the last 10 years of cases in other courts in which they interpret that second factor differently.
Yeah, I mean, I think one thing with regard to final thoughts, I will start with the Rosenberg decision. I think it was a good analysis of the case law, although I think that the second factor, I think, yes, there was not a great discussion with regard to when the judge said due and payable, but she also mentioned that at the point that she was making that decision, that the debtor was also not eligible for any of these repayment plans. So the loan really was due and payable. So the lender can't have it both ways. They can't say, oh, but you're eligible for this repayment plan. No, he wasn't. In the case, the debtor was not eligible for these repayment plans. The loan actually was due and payable. So I think what the Rosenberg highlights is this is a big issue. This, in my view, is the biggest consumer bankruptcy issue pending. It's a $1.6 trillion issue that should not be seen lightly, because as you can see with the election, it's reached a level where I think the pressure is now on that something must be done. The test is much too harsh. It's unclear how the courts are going to come out on it, how the courts see Rosenberg, but I think that most people that you ask see that there's something wrong. And I think the real challenge is going to be fashioning a test that is an appropriate balance between wanting to have a test that is reasonable for debtors that are worthy candidates of discharge relief, without it being so overly generous, which seems ridiculous now because it's so harsh, that it allows people to get a discharge that may not be worthy. But I think that we are so far from that really right now the first thing to look at is how the courts are going to address if we want to make it fair, how do we go about doing that?
We are at an end. We thank you all for your time and sharing your hour this morning with us.
And please feel free to send us questions. We will respond if anybody wants to text or email questions. Steve and I will be happy to respond. Thank you very much.
Thank you.